Good morning, afternoon, sir. State your name. I think you're on mute, sir. If there's a button in the middle of that, if you could hit that. Yep. Can you, hello, your name? No, still can't hear you. Counsel, you ready?
Yes, sir. I'm ready.
Thank you. And then, are you Mr. Jordan? Is that correct? Mr. Jordan, I can't hear you, sir. Maybe you can find a deputy or something. Yep, that button should do it for you. I still can't. I apologize. Can't hear you. Yep, take your time. Go ahead. Thank you.
Yeah, that is Mr. Jordan, though. Yeah.
Oh, thank you.
But,
that makes a difference.
Yeah, sorry. I was trying to see myself.
Yeah, no worries. Thank you for being patient. And this is the number they called. So maybe if the officer comes in and tries to help us with the microphone, we can ask him where Mr. Jordan's at.
Got it.
Good afternoon. I can't see it. If you could bring it a little closer. What's that saying, lady? On his way to fix it. Thank you. Appreciate it. Oh, here we are. Officer? Officer, I can't hear you. Still can't hear you, sir. And officer, is that Mr. Jordan? We're looking for Brandon Scott Jordan. And I still can't hear you. Oh, thank you. Yes, yep, that works. Thank you. I appreciate your assistance. And is that Mr. Jordan? Yes. Brandon Scott Jordan?
Yes, sir.
Okay, thank you. And good afternoon, sir. Thanks for your assistance on that. I appreciate that. Mr. Jordan, you're here for a couple of Thank you. Thank you. You're here for a couple of matters, sir. You have your counsel present. We'll go through them one at a time. And counsel, good afternoon. Thank you for your patience, sir. This first, we're handling case 200564007, People's State of Michigan versus Brian Scott Jordan, identified as defendant 1, also known as Raymond Mack, Rico Durrell Gatewood. Mr. Jordan, could you state your name, please?
My name is Brandon Jordan.
Thank you, sir. Counsel, your appearance.
And good afternoon, Your Honor. I'm Christopher Sinclair, appearing with and on behalf of Mr. Jordan. Today's the date and time set for arraignment. Ask the court to, just so I'm clear on which file we're addressing first, ask the court to read the charges, and then we stand mute.
Thank you, counsel. The allegations are count 1, assault with intent to do great bodily harm less than murder or by strangulation. It's a felony. Carries up to 10 years or $5,000 DNA to be taken upon arrest. Count 2, domestic violence, misdemeanor, 93 days and or a $500 fine with a habitual offender third offense notice. The court will enter a plea of not guilty and schedule two court dates, Mr. Jordan, that you must attend them both. A probable cause conference on November the 25th. You have a right to a preliminary examination December the 1st. Both at 8:30 a.m. 36th District Court in front of Judge Jones. Both of those hearings will take place via Zoom, which is an off-site streaming technology. We'll get you information on how to connect, Mr. Jordan, but it's your responsibility to connect on time. Not guilty pleas entered as the bond counsel.
Yes, sir. Mr. Jordan is 34 years old. He has 7 children that he cares for. He has ties to the community with an address in the city of Detroit. It's no secret that there's some priors on his record. As relates to the current file, it's my understanding there was a domestic disagreement.
Did you say no priors, counsel?
No. I said it's no secret that there are priors.
Thank you. I apologize.
Yeah, no problem.
Go ahead.
Let's see, what did I say after that? I said no secret that there are priors, and I said my understanding of the allegations on this file is that there was a domestic disagreement, and by the time the complaining witness made it to the police department, it went from like a low-level domestic disagreement to allegations that rise to the level of the great bodily harm charge. And I do understand the court has to take the charges as they see them and as they are in front of the court right now. But I'm confident in an outcome that doesn't include the charge of great bodily harm. So with all of that said, I'm asking for, given the situation, a low cash bond.
Thank you, Brother Counsel. And sir, did you address employment? Is he unemployed at this time, being incarcerated?
I'm sorry. At the time that he was taken into custody, he was working at a meat factory located in the city of Detroit, and he was also working with family members at different like construction-related jobs and things of that nature. So he was fully employed and has been continuously employed. And of
Thank
course,
you, Counsel. And he's currently on parole. Is that correct?
Yes, sir.
And then what charge is that he's on parole for?
That was assault with intent to great bodily harm from, I believe it was 2013.
Thank you, Counsel. I appreciate that.
I'm sorry, 2012. Thank you, Mr. Jordan.
Thank you. Yes, thank you, Mr. Jordan. Mr. Jordan, the court takes in consideration a number of things. Your attorney has advocated well on your behalf. The court takes this information into consideration, including but not limited to your current lack of employment as it relates to ability to post bond. You have ties to the community. The court's unaware of any capious history. These are very serious assaultive allegations, sir, and the court is concerned not only with these allegations, but also given your prior criminal convictions, which include an assaultive conviction, and as stated by counsel, you're currently on parole for an assaultive conviction, and we have allegations of this nature, which are very concerning. The court also takes consideration the information alleged in the investigator's report, which leans towards the likelihood of conviction, as well as the current epidemic facing the nation. During this bond, Mr. Jordan, you are not to purchase or possess a firearm or any other dangerous weapon. Do not go back to the area or premises of 15445 Monte Vista Street, Detroit, Michigan, 48238, and no contact with Amani Jordan. And that means no contact of any kind during this bond. No contact orally, in writing, through a third person at their place of residency, employment, or through any forms of social media. Absolutely no contact with Amani Jordan. Is that understood, Mr. Jordan?
Yes, sir.
Thank you. Given the information placed on the record provided by your counsel, the nature of these charges, serious assaultive allegations, and given the consideration of the current epidemic, as well as given the information investigators report, given the concerns the court has, as stated, you'll be fit with the GPS tether prior to release. Your bond is $7,510%. It's a $750 bond on that matter, sir. You have one additional matter, Mr. Jordan, and it's in regards to case number 200582211, People's State of Michigan versus Brandon Scott Jordan, identifying the complaint as defendant 2, also known as Rico Darrell Gatewood and Raymond Mack. Mr. Jordan, your name one more time, sir.
Brandon Jordan.
Thank you, sir, and again, good afternoon. Appearance, please.
Yes, good afternoon, Your Honor. I'm Christopher Sinclair, appearing with and on behalf of Mr. Jordan. Today's the date and time set for arraignment. We ask the court to read the charges, and then we stand muted.
Thank you, counsel. Mr. Jordan, you're here charged with count one, assault with intent to murder. It's a felony, carries life or any term of years, DNA to be taken upon arrest. Count two, assault with intent to do great bodily harm less than murder or by strangulation. Felony, 10 years or $5,000, DNA to be taken upon arrest. Count five, police officer fleeing third degree vehicle code. Felony, 5 years and or $1,000. Secretary of State shall suspend license for up to 1 year. And you have a habitual offender third offense notice, which increases the penalty twice the maximum sentence on a primary offense or lesser term. The court will enter a plea of not guilty, Mr. Jordan, and schedule the same 2 court dates as the latter matter. A probable cause conference November the 25th, which is a Wednesday. You have a right to a preliminary examination the following Tuesday, December the 1st. Both 8:30 a.m., 36th District Court in front of Judge Jones. As with the latter matter, the previous matter, Mr. Jordan, both of those hearings will take place via Zoom. That's an off-site streaming technology. You'll get information on how to connect, but it's your responsibility to connect on time. Not guilty plea is entered. As to bond.
All right, thank you, Judge. As stated previously, Mr. Jordan is 34 years old. He has, there are some items on his record. He was working at the time that he was taken into custody. He has 7 children and has ties to the city. My understanding of the allegations is that he was merely present and that he wasn't a person who actually had a weapon, as kind of reflected in the charges. There's no felony firearm or CCW or anything of that nature reflected in the charges against Mr. Jordan. It's also my understanding that someone who was associated with the kind of pulling the trigger or being the active person involved in these allegations has pled either in state court or to the parole board in a show of responsibility for their action in this matter. So this is a defendable matter. Mr. Jordan has a viable defense of just being merely present in this matter. And with these considerations, in addition to the consideration of course, the ongoing pandemic and the cases rising every day, the number of deaths rising every day, I'm asking the court for a low cash bond on this file as well.
Thank you, counsel. Mr. Jordan, as with the latter matter and always, your counsel's advocated well on your behalf, and the court takes into consideration the information he provided, including but not limited to the lack of capious history the court's aware of. The court has concerns, as stated, regarding your prior criminal convictions, which include assaultive convictions that, as stated by your counsel, you're currently on parole for, which is concerning to the court given the nature of these allegations, specifically count one, which is a possibility of a life offense or any term of years. You do have ties to the community the court takes into consideration, as well as the current epidemic facing the nation. The court's aware that you're currently unemployed and takes your employment status into consideration as it relates to the ability to post bond. Very concerning, sir, is the information alleged in the investigator's report. Not only does it allege, sir, that you are on parole, but at the time it indicates that you are on a tether, where a check of the GPS tether system puts you at the GPS precise geographic location, allegedly at the time and location of the shooting, and that's concerning to the court and leans towards the likelihood of conviction. The court also considers the nature of these charges as well as all allegations set forth in the investigator's report. Mr. Jordan, during this bond, sir, you are not to purchase or possess a firearm or any dangerous weapon, and absolutely no contact with Romario DeBarge Taylor. And that means no contact of any kind, sir. No contact orally, in writing, through a third person at their place of residency, employment, or through any forms of social media. Absolutely no contact. Is that understood, Mr. Jordan?
Yes, sir.
Thank you. Given the information placed on the record, the serious nature of these charges, the fact that you're on parole for an unrelated felony conviction, assaultive conviction, and your prior felony convictions in total, the bond on this matter is set in the amount $220,000 cash surety. Anything further, counsel?
I would just ask the court to consider a 10% provision on this matter, just most strongly pointing to the my representation that the person who's responsible for the actual action or the actual shooting or the firing of shots has already pled in this matter, which suggests, of course, that Mr. Jordan is not the person that that committed those acts and maybe responsible more so as a person being present while something else was happening. And that's my heaviest reliance in this matter, and asking the court to consider a 10% provision.
Okay, no, the court placed the concerns the court has on the record, and the fact that what you're indicating does not negate any possible convictions for any of these charges if these allegations are proven. These are just allegations, but what you're stating does not alleviate the court's concerns regarding the safety of the public, nor the other information that's placed on the record. And so the bond is set as indicated prior to any release. He's to be fit with the GPS tether. Anything further, counsel?
Just one more stab at it as it relates to the safety of the public. My understanding of the allegations is there's no allegation that Mr. Jordan had or possessed any weapon or fired any shots or did anything in this matter that would actually cause danger to the public. Of course, I can't, negate or dispute what the priors are, because those kind of, to put it colloquially, are what they are. But that's the fact that there's no allegation that I'm aware of that Mr. Jordan actually possessed a weapon. Like I said, would suggest to me that
the actual possession of a weapon and the nature of these charges is not an automatic defense, counsel.
I understand the elements of each charge, and I didn't say what I said to suggest that it was a defense. But one of the things, of course, that the court considers is, as the court stated, whether a person is a danger to the community. And I would
exactly. Let me address that. We just handled, counsel. Let me address that. He's on felony probation for a felonious assault. We just handled a prior matter where he allegedly picked up a number of allegations of assault of nature against the alleged victim. Now this is another matter before the court where we have allegations that are not only assaultive but include life offenses. So he has prior convictions for assaultive convictions. He's on parole for an assaultive conviction, and he has two very serious separate assaultive convictions before the court this afternoon. The one that we're talking about now is a possibility of a life offense. And so the court has great concerns regarding the safety of the public based on your client's prior actions and the information that's been placed on the record. Anything further?
Yeah, I just wanted to finish making my record before the court stopped me. That's all. Of course, the court has made its decision, but I just want my argument on the record. And just the small conclusion of it is that a suggestion of danger, in my view, would be lessened or minimized with the understanding that the person, that Mr. Jordan, did not have the weapon or anything of that nature. And that was
and you've stated that, and the court's taken that into consideration.
And again, what I'm saying, Your Honor, is I just wanted to put my argument on the record, and I understand the court has made its decision, so this record can be complete.
Anything further?
No.
Thank you, counsel. Good luck, Mr. Jordan.
Thank you.
You're welcome.
Have a great day, everybody.
You too, counsel. Thank you. Madam Clerk, I apologize. This top file, I just put the wrong number. Could you just make a photocopy of the other tops? So I put 220 on the others. I just wrote that one wrong. Okay. Make just one copy of that for me. Thank you. Okay. Good afternoon, DDC. Thank you for your patience. We just handled some matters in-house from this morning's docket at MDOC. How was your lunch? Did you get lunch?
It was great. Thank you.
Happy to hear it.
You know, they took that traffic course, so we get a lot more time. So we get a break now.
You're the first person I thought of when they took those away, and I'm happy to hear that. Gives you a little bit of time to eat.
I had a feeling you would say that. Are you ready to start?
Absolutely, officer. Absolutely. At your pleasure, sir. We have counsels ready, all the files present. I believe everybody's been interviewed.
Straight down.
Good afternoon. Your name, please.
Bowers.
Mr. Bowers, is that correct?
Yes, sir.
Thank you. Good afternoon, sir. Mr. Bowers, you're here for case 200611927, People State of Michigan versus Tajri Bowers. Brother Counsel.
Yes, Your Honor. Brendan Bird on behalf of Tajri Bowers, my client has waived his right to formal reading, understands his constitutional right to stand mute.
Thank you, Counsel. Court waive formal reading under a plea of not guilty. The court is scheduling a probable cause conference, sir, that you must attend on December the 16th, which is a Wednesday, 8:30 a.m., 36th District Court in front of Judge King. That hearing, sir, will take place via Zoom. That's an off-site streaming technology. Before you're released, you'll get information on how to connect for that hearing, but it's your responsibility to connect on time, understand?
Yes, sir.
Thank you. Not guilty is entered as the bond.
The bond, Your Honor, my client indicates that he's a 19-year-old lifelong resident in Detroit. He also indicates that he has no prior criminal conviction. He's a high school graduate, not on probation or parole, and respectfully, Your Honor, this is not a soft allegation. Respectfully ask the court to reverse the bond.
Thank you, counsel. Mr. Bowers, this is a very serious felony allegation, sir. It's very important you listen to the court so you don't get locked back up just for not listening. Does that make sense?
Yes, sir.
Mr. Bowers, the court considers the advocacy provided by your counsel. The court's unaware of any prior criminal convictions or capious history. You have ties to the community. The court considers the current epidemic facing the nation as well as employment status as stays relates to ability to post bond. This is a serious charge, Mr. Bowers, but non-assaultive, and the court's reviewed and considered the information alleged in the investigator's report. During this bond, Mr. Bowers, you are not to go to the area or premises of any Myers store. Do you understand?
Yes, sir.
Given the information placed on the record, bond will be set $5,000 personal bond. You're being released, Mr. Bowers. Good luck, sir. Listen to the court. Welcome, counsel. Good afternoon. Your name, please.
Q. Crocker.
Thank you, Mr. Crocker. Mr. Crocker, you are here for case number 200612238, People State of Michigan versus Lamont Crocker, also known as Lamont Q. Crocker. Counsel.
Yes, Your Honor. Brandon Bird on behalf of Lamont Crocker, my client waives his right to formal reading, understands his constitutional right to stand mute.
Thank you. Brother Counsel, court waive formal reading of the information under a plea of not guilty. Mr. Crocker, the court is scheduling a probable cause conference, sir. You must attend Wednesday, December the 16th, 8:30 a.m., 36th District Court in front of Judge King. That hearing, Mr. Crocker, will take place at 8:30 via Zoom, which is an off-site streaming technology. Before you're released, you'll get information on how to connect for that Zoom hearing, but it's your responsibility to connect on time. Do you understand?
Yes. Yes.
Thank you. Thank you, Mr. Crocker. Not guilty, plea is entered. As the bond.
At the bond, Your Honor, my client indicates that he's a 21-year-old lifetime resident in Detroit. He also indicates that he has no prior criminal convictions. He's gainfully employed at Amazon as an Amazon delivery driver, high school graduate, not on probation or parole. And this is serious, non-assault allegation. Your Honor, we respectfully ask the court to reverse the bond.
Thank you, counsel. Mr. Crocker, the court has listened and taken into consideration the advocacy information provided by your attorney, who has done a good job, as always, on your behalf. You have no criminal convictions, no capious history. The court considers your ties to the community, the nature of this charge, which is very serious, Mr. Crocker, but it's non-assaultive. The court also considers the current epidemic facing the nation and employment status, as counsel stated, as it relates to ability to post bond. During this bond, Mr. Crocker, you are not to purchase or possess a firearm or any other dangerous weapon, understand? No weapons. And you're going to be released on a $7,000 personal bond, Mr. Crocker. Good luck, sir.
Thank you, Your Honor.
You're welcome. Good afternoon, Mr. Parker. Sir, you're here for, thank you. You're here for case 200611930, People State of Michigan versus Terrence Christopher Parker. Counsel.
Yes, Your Honor. Brandon Bird on behalf of Terrence Parker, my client waives his right to formal reading, understands the constitutional right to stand mute.
Court waive formal reading under plea of not guilty. We'll get to the court date in a moment as the bond.
One moment, Your Honor.
Take your time.
Okay, now, no crime indicates that he's a 27 lifelong resident in Detroit now. He's unemployed right now, so he would have difficulty paying the high monetary fine or monetary fine at all. He indicates that he's not on probation in the road, Your Honor. Especially, Your Honor, he got a very serious allegation, very serious allegation. But they are non-assault in nature. I would like to know that his last conviction is shown in the information is happened 9 years ago. So, especially, Your Honor, especially at this court for personal bond.
Thank you, Brother Counsel. Mr. Parker, the court takes into consideration the information provided by your attorney, included but not limited to your current lack of employment status as it relates to the ability to post bond. The court considers the nature of these charges, which are serious but not assaultive, the current epidemic facing the nation, as well as your prior criminal conviction, sir, which the court notes the age of that matter, also the nature. The conviction was for an armed robbery, and that's concerning to the court as a very serious assaultive conviction. The court has also read and considered the information alleged in the investigator's report, as well as your ties to the community. Mr. Parker, during this bond, there's no use of alcohol, no marijuana, and no illegal controlled substance, and you're not to purchase or possess a firearm or any other dangerous weapon. Do you understand?
Yes, sir.
Mr. Parker, do you have any issues with complying with any court's condition?
No, sir.
And if
No,
the
Your
court
Honor.
were to release, if the court were, you're fine. If the court were to release you on a personal bond, Mr. Parker, you're confident that you can tell the court you're going to listen, refrain from any drugs or alcohol, no weapons, and you're going to make your court date. Is that what you're telling the court?
Yes, Your Honor.
It's very important that you do just that, Mr. Parker, so you don't get locked back up just for not listening. The court's scheduling a virtual hearing. Make sure and listen to the court and attend the virtual hearing, which is scheduled December the 15th. That's a Tuesday, 8:30 a.m., 36th District Court in front of Judge Archer. As stated, Mr. Parker, that will be a virtual Zoom hearing, and you'll get information on how to connect before you're released. But it's your responsibility to connect on time and follow all court's orders. Understood?
Yes, Your Honor.
Okay, and that includes, as stated, no alcohol, no marijuana, no illegal controlled substance, and you're not to purchase or possess a firearm or any dangerous weapon. Given the information placed on the record that concerns the court has nature of these charges, as well as your lack of employment status, bond will be set $14,000 personal bond. You're being released on a personal bond, Mr. Parker. Good luck, sir. Listen to the court. December the 15th, 8:30. Yes, good luck. Good luck, Mr. Parker. You're welcome, sir. Yes, sir, you're welcome. You doing okay, love? Good afternoon. Your name, please.
Good afternoon, Jamel Peterson.
Thank you, Mr. Peterson. Sir, you're here for case 200-45892, People State of Michigan versus Jamel Cesara Peterson, Brother Counsel.
Yes, Your Honor. Brandon Bird on behalf of Jamel Peterson. My client is raised his right to the formal read. Understand the constitutional right to stand mute.
Court waive formal reading under a plea of not guilty. We'll get to the court date in a moment. Well, the court date is going to be December the 9th, which is Wednesday, 8:30 a.m., 36th District Court in front of Judge Garrett. Mr. Peterson, that court date will take place via Zoom. That's an off-site streaming technology. You'll get information on how to connect for the hearing, but it's your responsibility to connect on time. Not guilty, please enter it as to bond.
Mr. Bond, Your Honor, my client in the case is that he is 41-year-old lifetime resident in Detroit, Your Honor. And unfortunately, he's unemployed right now, so it's difficult for him to pay his time. He does have some college behind him. In the case does say he's not on probation or parole, understands that he can't have any contact with the toxic drug. He's complaining that he needs no contact with the claim units at all. And especially, he is living with his wife currently right now. Understandably, that he is the second violation of his allegation. But I would like to keep taking into account that it is with me, Your Honor. And he does understand no contact and we respectfully ask this court for a personal bond.
Thank you. Brother counsel, for the information you provided, and Mr. Peterson, the court takes that information into consideration, as well as your ties to the community, the current epidemic facing the nation, as well as, you said he's unemployed, correct? He's unemployed?
Yes, sir.
Thank you. And as well as your lack of employment at the time regarding the as it relates to the ability to post bond. Mr. Peterson, this is a very serious assaultive allegation. The court has concerns regarding your prior conviction, which is a assaultive conviction similar in nature to the allegation before the court. You, as stated, you do have ties to the community, and the court's read and reviewed the investigator's report, taking into consideration the allegations set forth therein. During this bond, Mr. Peterson, you are not to purchase or possess a firearm or any dangerous weapon, and absolutely no contact with the area or premises of 18410 Mark Twain, Detroit, Michigan. And no contact during this bond with Latasha Rudd. That means no contact of any kind. No contact orally, in writing, through a third person at Ms. Rudd's employment, home, residency, or any forms of social media. Absolutely no contact with Ms. Rudd. Do you understand, Mr. Peterson?
Yes, I do.
Thank you.
I just like to stress that the first violation of this allegation, Your Honor, did happen about 6 years ago, over 6 years ago.
The first conviction you stated?
Right, first conviction.
Thank you.
That has been said.
For the reasons placed on the record provided by counsel, the nature of this charge, which is a serious assaultive, as well as the allegations set forth in the investigator's report, given you are to be filled with the GPS tether prior to release, given the information in the investigator's report, your bond is set due to your lack of employment and the information placed on the record, 1,510%. You're welcome. That's $150, Mr. Peterson. Listen to the court. No contact with Miss Rudd. Good luck, sir. Welcome. I'm well, thank you for asking. How are you?
I'm doing fine.
Well, I'm happy to hear that. You said Ian Matthews, is that correct, sir?
Yes, Your Honor.
Thank you. Mr. Matthews, you're here for case number 200619636, People State of Michigan versus Ian Matthews, also known as Ian Ellis. Counsel.
Yes, Your Honor. Brandon Bird on behalf of Ian Matthews, my client, Wade, understand his constitutional right to stand you.
Thank you, brother counsel. Court waive formal reading, enter a plea of not guilty, Mr. Matthews, and the court is scheduling a probable cause conference, sir. You must, or actually, the court's scheduling two court dates, a probable cause conference November the 25th.
Okay.
As you have a right to a preliminary examination December the 1st. They're both at 8:30 a.m., 36th District Court in front of Judge Jones. Both of those hearings will take place, sir, via Zoom, which is an off-site streaming technology. You'll get information on how to connect for those hearings before you're released or able to make bond, but it's your responsibility to connect on time. November 25th, December 1st, in front of Judge Jones at the 36th District Court at 8:30. Do you understand?
Yes, Your Honor.
Thank you. Not guilty is entered as the bond.
Your Honor, my client indicates to us that he's a 25-year-old lifetime resident of Detroit County. He also indicates to us that unfortunately he's unemployed right now, but he does collect Social Security disability numbers, high school graduate. My client does suffer from mental issues and medication.
If we could mark his file medical for the reasons stated by counsel, officer, thank you, please. You're welcome.
And he also indicates that he's not on probation for parole. Respectfully, Your Honor, he understands that he has to stay away from the complaining witness in this case. And understandably, this is the third defense notice for this allegation. But, Your Honor, respectfully, ask the court for a high personal amount of reasonable 10% of the housing.
Thank you, counsel. Mr. Matthews, this is a very serious assaultive allegation, sir, and the court takes into consideration your ties to the community, the information provided by your attorney, including but not limited to employment status as it relates to ability to post bond. The court considers the current epidemic facing the nation as well as the information alleged in the investigator's report. Mr. Matthews, you had prior convictions, felony convictions included, but prior misdemeanor convictions on a similar related offense as what's before the court on count 1. Were those prior convictions against Mr. Leslie Lyles as well?
No, Your Honor. That was like 2 years ago, I believe, a year ago.
That's how you don't have to say anything else about it, Mr. Matthews. I just wanted, you're being recorded, sir, so I would like, you don't have to give any more information than you'd like. I just was curious if that was against the same alleged victim, and then thank you for that information that it was not, and the court takes that into consideration. Regardless, this is a very serious allegation, and the court has concerns regarding your prior your prior convictions, assaultive convictions. During this bond, Mr. Matthews, you are not to purchase or possess a firearm or any dangerous weapon, and do not go back to the area or premises of 550 Trumbull, Detroit, Michigan. And absolutely no contact with Leslie Lyles. No contact during this bond means no contact of any kind. No contact orally, in writing, through a third person at their place of residency, employment, or through any forms of social media. Absolutely no contact. Do you understand?
Yes, sir. I understand. Yes, sir.
Thank you. And prior, if you're able to make bond, you're to be fit with the GPS tether given the allegations before the court and your prior convictions. Given the information alleged in the investigator's report, bond on this matter will be set in the amount.
I'll make it to court and everything, Your Honor.
What's that, sir?
I'm sorry, I didn't mean to say anything, but I was gonna say I can make it to court and everything. That's no worries, no problems, anything.
Okay, not only to make it to the court, sir, no contact with Mr. Lyles as well. No contact, sir.
Yes, sir. I'm going to Ypsilanti. I'm not going to stay out here in Detroit, Michigan no more. So I was going to go to Ypsilanti.
Okay, well, make sure and attend your court. Thank you. Bond on this matter is set in the amount $6,010%. That's $600 bond, Mr. Matthews. Good luck, sir. Close that. Okay, thank you. You're welcome. Good afternoon, sir. Your name, please. Thank you, Mr. Duffy. Mr. Duffy, you're here for case 2006192, People State of Michigan vs. Kevin Antonio Duffy. Brother Counsel.
Yes, Your Honor. Brandon Bird on behalf of Kevin Duffy. I waive his right to formal reading, understand the constitutional rights of the stand.
Thank you, sir. The court waive formal reading of the information under plea of not guilty. Mr. Duffy, the court is scheduling a probable cause conference, sir. You must attend on Wednesday, December the 16th. That's at 8:30 a.m., 36th District Court in front of Judge King. Mr. Duffy, that hearing, sir, will take place via Zoom, which is an off-site streaming technology. You'll get information on how to connect for that Zoom hearing before you're released, but it's your responsibility to follow the court's orders and attend that Zoom hearing on time. Do you understand?
Yes.
Thank you, Mr. Duffy. Not guilty is entered as the bond.
That's fine, Your Honor. My client indicates to the 32-year-old lifetime resident of Detroit. He gainfully employed in the bargaining allegation was EOC, non-assault allegation.
Thank you, counsel. Mr. Duffy, it's a very serious allegation, sir, but it is non-assaultive. The court notes that the court is unaware of any capious history or criminal convictions. The court notes you have ties to the community and consider the information provided by counsel as well as the allegations set forth in the investigator's report and the current epidemic facing the nation, as well as employment status as stated as relates to ability to post bond. Mr. Duffy, during this bond, you are not to purchase or possess a firearm or any dangerous weapon. Do you understand?
Yes, sir.
Thank you. For those reasons, the nature of this charge, the epidemic facing our nation, bond will be set $7,500 personal bond. You're being released, Mr. Duffy. Listen to the court, sir. Good luck. You're welcome, counsel.
Your nose and mouth, brother. Nose and mouth. Thank you.
Thank you, officer. Good morning. Good afternoon, sir. Your name, please.
Durante Turner.
Thank you, Mr. Turner. Mr. Turner, you're here before the court, sir, on case number 2006193, People State of Michigan versus Durante Turner. Brother counsel.
Bring Bird on behalf of Durante Turner. My client waives his right to formal reading. Understand the constitutional rights and understand
For waive formal reading and her plea of not guilty. Mr. Turner, the court's scheduling a probable cause conference, sir, that you must attend December the 15th, which is a Tuesday. That's at 8:30 a.m., 36th District Court in front of Judge Archer. Mr. Turner, that hearing will take place via Zoom. That's an off-site streaming technology. Before you're released, you'll get information on how to connect for that court date, but it's your responsibility to connect on time. Do you understand? Thank you. Not guilty is entered as the bond.
At the bar, Your Honor, my client in the case to us that he is, lifetime resident in Detroit. He also indicates to us that he has no prior criminal conviction, not on probation for sanctioning employed at Women's Bar and Grill. And respectfully, Your Honor, this is a non-assaultive allegation, but we respectfully ask the court for a personal matter.
Mr. Turner, this is not assaultive, sir, but it's a very serious felony allegation. It's very important you listen to the court so you don't get locked back up just for not listening. That makes sense, correct?
I'm sorry. I appreciate you.
But no worries, Mr. Turner. Mr. Turner, the court takes into consideration upon setting a bond a number of things. Your counsel's advocated well on your behalf. You have ties to the community. The court is unaware of any criminal convictions in the past or capious history. The court considers your employment status, as counsel stated, as relates to ability to post bond, as well as the current epidemic facing the nation, nature of these charges, are charged, as well as the allegations set forth in the investigator's report. Mr. Turner, during this bond, sir, you are not to purchase or possess a firearm or any other dangerous weapon. Do you understand? Thank you. And Mr. Turner, for those reasons, you're going to be released on a $7,500 personal bond. You don't have to post any money, sir. Listen to the court, no weapons, and make sure to attend that Zoom hearing December the 15th. Good luck, Mr. Turner.
Okay, thank you. I appreciate you, sir.
You're welcome, Mr. Turner. Take care, sir. Be safe.
How about now?
7,500 personal. No weapons.
White line first. Say your name, bro.
Good afternoon, Your
Good
Honor.
afternoon. Good afternoon. Your name, please?
Michael Rhodes.
Thank you, Mr. Rhodes. Mr. Rhodes, you're here for case 2006193, People State of Michigan versus Michael Laverne Rhodes. Brother counsel.
Yes, Your Honor. Bring Bird on behalf of Michael Rhodes. My client waives his right to formal reading. Understand the constitutional rights and stand these.
For a waive formal reading and her plea of not guilty, we'll get to the court date in a moment as to bond.
One moment, Your Honor.
Take your time.
Okay, my client indicates to us that he is a 54-year-old lifetime resident of Detroit, Your Honor. He's employed at Deadlock, indicates to us that he's not on probation for parole, Your Honor. And understandably, I understand it's a victim third offense notice, Your Honor, but according to the information, the previous conviction is respectfully, these are serious allegations, Your Honor, respectfully as the court, they are non-assault, respectfully as the court for personal violence.
What does he do for bedrock? What's that, sir?
Janitorial.
Okay, thank you, Mr. Rhodes, and good luck with your employment. I hope it continues to work out well for you. Mr. Rhodes, these are very serious allegations, sir. The court considers you have ties to the community, no capious history. The court has Listen and consider the information advocacy provided by your attorney, and consider the current epidemic facing the nation, as well as the allegations set forth in the investigator's report. You have prior felony convictions which are concerning to the court and taken into consideration, as well as your employment status as stated as relates to ability to post bond. Mr. Rhodes, the court is scheduling a probable cause conference, sir, that you must attend December the 16th, which is a Wednesday, 8:30 a.m., 36th District Court in front of Judge King. That hearing, Mr. Rhodes, will take place via Zoom, which is an off-site streaming technology. You'll get information on how to connect for that hearing before you release, but it's your responsibility to connect on time. Do you understand?
Yes, sir.
Thank you. And during this bond, Mr. Rhodes, there's no use of alcohol and no illegal controlled substance. And you're not to purchase or possess a firearm or any other dangerous weapon. Is that understood?
Yes, sir.
Are you working given the current shutdown? Are you currently working, or are you off work right now?
Yeah. Yes, we are, Your Honor.
What hours are you working, sir?
From afternoon, from 1 to 1.
Monday through Friday, or what days a week? 7 days, 5 days?
5 days, Your Honor.
Monday through Friday?
Yes, sir.
From 1 p.m. till 1 a.m.?
Yes, sir.
How long does it take you to get home or get to and from work?
Half an hour to an hour.
Okay, so you're based on the nature of these charges and your priors and the information alleged in the investigator's report, you're going to be released on an $11,000 personal bond. You don't have to post any money, but the court is going to fit you with a GPS tether prior to release. Mr. Rhodes, the court will allow you to go to and from work. So would an hour be enough time to get to and from work, or do you need more time, or is an hour enough time?
More time, Your Honor.
Hour and a half?
Yes, that'll go. Yes, sir.
Okay, so the court's going to allow you to go to work Monday through Friday from 11:30 a.m. until 2:30 p.m. And Mr. Rhodes, if you get off earlier, you're to go home. Don't be staying out and about at those hours unless you're working. Okay, Mr. Rhodes?
2:30 p.m. or 2:30 a.m.?
I think 2:30 a.m. Did I say p.m.?
Yeah.
So it's 11:30 a.m. to 2:30 a.m. Thank you, counsel. And so the court will indicate that on the MIT, Mr. Rhodes. You're being released on a personal bond. Good luck, sir. I hope it all works out for you. You're welcome.
White line, brother, first and last name? Say your name?
Daquan Moore.
Good afternoon, Mr. Moore. Just one moment, sir.
You don't mind if I take a second to browse the report one more time, y'all?
Absolutely not. Yes. One moment, Mr. Rhodes. Your attorney's reviewing information to help in your representation. Just one moment. I'm sorry, not Mr. Moore. One moment, sir. Oh, wait. That's counsel.
Oh, you about to get ready to go, Ryan? Get it around.
Try again.
And 4.
When you get, see me later. When you come back. I'm right here when you get done. What's your name?
I printed some. So she working for doing that?
Thank you.
Thank you, Your Honor.
Thank you for your patience, DVC, as well as Mr. Moore. Mr. Moore, could you state your name one more time, sir?
Daquan Ford.
Thank you. And you're here for case 200-618-37, People's State of Michigan versus Daquan Devon Moore, identified in the complaint as defendant 2. Brother counsel.
Yes, Your Honor. Brandon Bird, on behalf of Daquan Moore, my client, waives his right to formal reading. Understands his constitutional rights, will stand mute.
Court waive formal reading and her plea of not guilty. Mr. Moore, the court scheduling 2 court dates, sir. You must attend them both. Probable cause conference November the 25th, which is a Wednesday. You have a right to a preliminary examination the following Tuesday, December the 1st. They're both at 8:30 a.m., 36th District Court in front of Judge Jones. Mr. Moore, both of those hearings, sir, will take place via Zoom. That's an off-site streaming technology. You'll get information on how to connect, but it is your responsibility to connect on time. Not guilty plea is entered. As to bond, brother counsel.
At the time, Your Honor, my client indicates that he's an 18-year-old lifetime resident of Detroit, Your Honor. He also indicates that he has no prior criminal conviction at all. Unfortunately, he's unemployed right now, but he is a high school graduate. He indicates that he's not on probation or parole. After reading the report, Your Honor, there are a couple things that I'd like to point out. First of all, in the summary, I really don't appreciate how it's written. It's written as if the writer actually witnessed the incident and that it's the truth and not allegations. But secondly, Your Honor, there are 2 different witnesses that state that 2 different people allegedly created these allegations. Respectfully, Your Honor, he doesn't have any prior. He is 18 years old. He's unemployed right now. But respectfully, I understand these are very, very serious allegations. So high personal bond with the GPS or reasonable 10% bond in the court.
Thank you, counsel. Mr. Moore, these are very serious assaultive allegations, sir. The court takes into consideration the information provided by your attorney, including but not limited to your lack of employment status as it relates to ability to post bond. The court is also unaware of any prior convictions or capious history, and the court takes into consideration the nature of these charges, which are very serious assaultive allegations, specifically counts 1 and 2, both possibility life offenses. The court has also considers the current epidemic facing the nation and has read and considered the allegations set forth in the investigator's report, which the court finds very concerning regarding the safety of the public. And the court notes that the investigator's report leans towards the likelihood of conviction. It's alleged, sir, that an individual observed you produce a pistol and fire approximately 10 shots, striking an individual, resulting in approximately 11 bullet hole wounds, including exit wounds.
There's also a witness that states that somebody else is the one that actually did the shooting.
Right, and And the court's read and considered all the information in the investigator's report. And thank you for that, counsel. The court considers the lack of capious history as well and the nature of these charges, given the court concern regarding the safety of the public, specifically the safety of the alleged victim. During this bond, sir, you are not to purchase or possess a firearm or any dangerous weapon, and absolutely no contact with Ellery Eugene Murray Jr. and no contact with Eshawanda Michelle Smith. And no contact, sir. Thank you. And no contact means no contact of any kind. No contact orally, in writing, through a third person at their place of residency, employment, or through any forms of social media. No contact with either of those individuals. Is that understood, Mr. Moore?
Yes, sir.
Thank you. And if you're able to make bond, sir, based on the information placed in the investigator's report as well as the nature of these charges, you're to be fit with a GPS tether. Bond on this matter set in the amount $450,000 cash surety. You're welcome. Good luck, Mr. Moore. Good afternoon. Your name, please.
Jason Carter.
Thank you, Mr. Carter. Good afternoon. Mr. Carter, you're here before the court, sir, regarding case number 19046-435, People's State of Michigan versus Jason Jesse Carter.
Yes, ma'am. I'm trying to heard on behalf of Jason Carter, my client, waived his right to under the constitutional right to defend.
Thank you. Court waive formal reading and our plea of not guilty. Court scheduling a pre-trial date, sir. You must attend December the 14th, 8:30 a.m., 36th District Court in front of Judge Bryant. That hearing, sir, will take place via Zoom. That's an off-site streaming technology. If you're able to make bond, you are to attend that Zoom hearing at 8:30 on time, and we'll get you information on how to connect. But it's your responsibility to connect on time. Understood?
Yes, sir.
Thank you. Not guilty is entered as the bond.
My client indicates that he's a 22-year-old lifetime resident of Detroit. He also indicates that he's right now for a difficult monetary bond. But he's not on probation or parole, Your Honor, and he lives with his grandparents here in Detroit. His copy of all of that, Your Honor. Well, respectfully, Your Honor, I understand he got serious allegations. And I would like to take into account that
Thank you. Mr. Carter, this is a capious bond, sir. This bond, you're here before the court because a warrant was issued for your arrest for failing to appear on or about September the 9th of 2020. And when you failed to appear, the judge you were assigned to issued a warrant for your arrest and placed a bond in the amount of 510%. Based on the nature of this charge, the information placed on the record, the current epidemic facing the nation, as well as your capious history and lack of employment status as it relates to ability to post bond, will remain the same as Judge Bryant stated on capious, 510%. And during this bond, Mr. Carter, you are not to purchase or possess a firearm or any dangerous weapon. Absolutely no contact with Jonathan Myrick and no contact with Dominique Carter. And that means no contact of any kind, sir. No contact orally, in writing, through a third person, at their place of residency, employment, or through any forms of social media. Absolutely no contact with either of those individuals. Is that clear?
Yes, Your Honor.
And if you're able to make bond, you're to be fit with the GPS tether. Good luck, sir. I hope it works out for you. Listen to the court. Thank you. Oh, you have one more matter, sir? Come back. 510%, no weapons, no contact with the tether. 1 second, sir, you have additional matter. Thank you. what's going on there. Okay. Your name one more time, sir?
Jason Carter.
Thank you. Ms. Carter, this latter matter is 200-61674, People State of Michigan versus Jason Jesse Carter, also known as Jason Jesse Carter, Jason Jesse Carter, the second Jason Carter. Brother Counsel.
Yes, Frank Bird on behalf of Jason Carter. I'm trying to waive right before
Thank you, sir. The court will waive formal reading of the information under a plea of not guilty. Mr. Carter, on these allegations, sir, the court's scheduling a probable cause conference on November the 25th. You have a right to a preliminary examination December the 1st, both 8:30 a.m. 36th District Court in front of Judge Jones. Both of those hearings, sir, as with the prior matter, will take place via Zoom, which is an off-site streaming technology. You'll get information on how to connect, but it's your responsibility to connect on time. Not guilty, please enter as the bond.
Lifetime resident in Detroit. Stated earlier, Your Honor, I'm going to just pull it right now. This is going to take my 3 months. Not on probation, though. For this was granted here in the Metro Detroit area. And respectfully, Your Honor, I understand you have very serious allegations. Very serious allegations. Respectfully, Your Honor, we're already for 5 months.
Thank you, counsel. These are very serious allegations, sir. And Mr. Carter, the court's had opportunity to review the investigator's report and has concerns regarding the safety of the alleged victims. The court notes the information provided by counsel, including but not limited to your lack of employment status as it relates to ability to post bond, ties to the community. The court has concerns regarding your prior matter, which is a capias, sir, that tells the court you do not appear as ordered on unrelated matters, and that was an assaultive allegation. And that concerns the court regarding your intention to appear and handle this matter as ordered. The court's also considered and taken into account the current epidemic facing the nation. 1 second, Mr. Carter, I'll give you a chance to speak, sir, as well as the information alleged in the investigator's report and your, as stated, lack of employment status as relates to ability to post bond. Do you have a statement or a question, Mr. Carter? You are being recorded, sir.
Yes, Mr. Carter, this is your attorney speaking. And I would like to just remind you, as the magistrate did, that you are being recorded. Please don't go discuss any facts of any of these cases over this video or on the phone while you're in jail. And if only ask questions that involve, have something to do with your bond.
That was your attorney speaking. Go ahead.
All I had to say was that, like before the prior, like I knew about the case, all that. I was going to every court case. I attended everything. All that. My last court date that I knew of was supposed to be set for, I think it was my pre-trial for the prior case was March 19th. I never, after that, the corona and everything like that had happened, so everything was postponed. After that, I never received a letter in the mail saying that I had to come to court. None of that. Like I said, when I got arrested today, they said it was a warrant.
Did you call the court and say, what's going on with my court date?
No, sir, I didn't.
Why not?
I just assumed that, like I said, I knew it was a serious matter, that when I had to take care of it, something would get sent to the house or anything, the mail.
Right. But Mr. Carter, I appreciate that, but Mr. Carter, you yourself just stated it's a serious matter. And being a serious matter, you have business to take care of in some form or fashion. And being that it is a serious matter, you went from, you're telling the court from May all the way up until November on a serious matter where there's a possibility that you could have a warrant for your arrest. And you just chose not to even look into it nor call the court or contact the court. And that's concerning. Anything else?
No, Your Honor.
Anything else, Mr. Carter?
No, sir.
Okay, thank you. And I appreciate the information provided by your counsel as well as yourself. Mr. Carter, during this bond, for the reasons stated, you are not to purchase or possess a firearm or any dangerous weapon. Absolutely no contact with Jasmine Page, no contact with Dominique Carter, no contact with Jonathan Myrick, and no contact with Ashley Thompson. And that all means no contact of any kind. No contact orally, in writing, through a third person, at their place of residency, employment, or through any forms of social media. Absolutely no contact with any of those individuals. Is that clear?
Yes, sir.
And Mr. Carter, prior to release, you're to be fit with a GPS tether. And that's included, and there's allegations of presence of threats on each of those individuals' life alleged in the investigator's report. Allegedly, you made a threat on every one of their lives, and according to the allegations set forth, and that's concerning to the court regarding their safety. Given your capious history, as well as the assaultive allegations set forth in the investigator's report, and the information placed on the record, including but not limited to lack of employment status and the current epidemic facing the nation, bond on this matter will be set in the amount $20,000, 10%. Good luck, Mr. Carter. You're welcome, counsel.
That's all the males we have. You have any more men?
No, sir. We'll meet you on the female side.
Copy that.
Thank you, sir. When did you swap out over there, Kurt? Thank you.
Juanita Janelle Porter Gross. Good afternoon, officer. Your Honor.
Good afternoon, Miss Porter. And Miss Porter, you're here for case 200-61935, People State of Michigan versus Juanita Janelle Porter, also known as Juanita Gross. Brother Counsel.
Yes, sir.
Thank you, sir. The court will waive formal reading of the information. Stand mute under a plea of not guilty on your behalf, ma'am, and the court is scheduling probable cause conference you must attend December the 16th, which is a Wednesday. That's at 8:30 a.m., 36th District Court in front of Judge Giles. That hearing, ma'am, will take place via Zoom, which is an off-site streaming technology. Before you're released, you'll get information on how to connect for that Zoom hearing, but it is your responsibility to connect on time. Do you understand?
Yes, sir.
Thank you. Not guilty. Please enter it as the bond.
She is a 44-year-old lifetime resident of Detroit County. She also indicates that she's self-employed. She is college educated, not a probation role. This is a non-assault allegation, Your Honor. Those serious non-assault. So respectfully, as a personal line.
Thank you, Brother Counsel. These are very serious allegations. It's a very serious allegation, ma'am, and the court takes into consideration the information your attorneys provided, your prior felony conviction, you have ties to the community. The court considers the current epidemic facing the nation as well as employment status as relates to ability to post bond. It appears that you have a warrant for your arrest out of Dearborn. Is that correct?
I wasn't aware of that, Your Honor.
Okay. Ms. Porter, during this bond, ma'am, you're not to use any alcohol, no marijuana, and no illegal controlled substance, and you're not to purchase or possess a firearm or any other dangerous weapon. Understood?
Yes, sir.
And it does not appear you have a valid driver's license. Is that correct?
Yes, sir. I was speaking of my maintenance man, but I shouldn't have been driving. I asked my son to take me, and
Miss Porter, Miss Porter.
Miss Carter. Porter.
Yes.
This is a brand bird. This is your attorney speaking. Please do not go into the fact of the case over this video or the phone while you're in jail, because everything is being recorded and to be used against you. I want you to get the best possible defense for your case. And
okay.
only ask questions that address violence. please.
Thank you. And Ms. Porter, during this bond, as stated by yourself, you don't have a license. So there's to be no driving, no driving. And very important, no alcohol, no marijuana, and no illegal controlled substance, and no weapons. If you violate in any way, in any form, you're likely to get locked back up just for not listening to the court. So it's very important you listen in all aspects, understood?
Yes, sir.
Thank you. Given an epidemic facing the nation, the information presented by your counsel and alleged investigators report and the nature of this charge, bond on this matter will be set in the amount $11,000 personal bond. You're being released, Ms. Porter, on a personal bond. Listen to the court and make sure to attend that Zoom hearing December 16th. No drugs or alcohol, no weapons. Good luck, ma'am.
Thank you, sir.
You're welcome. No driving. Good afternoon. Your name, please.
Tiffany Lorraine Huffman.
Thank you, Ms. Huffman. And you're here for case 200445251, People's State of Michigan versus Tiffany Lorraine Huffman, counsel.
Yes, ma'am. On behalf of the waive the right to formal relief. Understand the counsel has the right to stand you.
Court will waive formal reading and her plea of not guilty and schedule a pre-trial date. Ms. Huffman, you must attend December the 14th. That's at 8:30 a.m., 36th District Court in front of Judge Bryant. That hearing will take place via Zoom, which is an off-site streaming technology. You'll get information on how to connect before you're released, but it's your responsibility to connect for that Zoom hearing on time. Do you understand?
Yes.
Thank you. Not guilty is entered. Esteban.
My client case says that she's 29-year-old lifetime. Sorry, ma'am. My client in the case says that she's 29 years old. Also in the case says that she has no prior criminal conviction. She's not on probation for she is employed at job, walking in the grocery store, and she lives with her mother and kids. She also did this allegation also happened around a year ago, and respectfully, she understands that she has no contact with the plaintiff with, and will have no contact with the plaintiff with, but respectfully as a court.
Thank you, counsel. Ms. Huffman, your attorney's advocated well on your behalf as always. Court takes into consideration presented by your attorney, including but not limited to your employment status at the two jobs as it relates to the ability to post bond, your ties to the community, lack of capious history or criminal convictions the court's aware of. The court considers the current epidemic facing the nation as well as the concerning allegations set forth in the investigator's report. And the nature of this charge, this allegation is a very serious assaultive allegation. Ms. Huffman, you have ties to the community, it appears as well. During this bond, you are not to purchase or possess a firearm or any dangerous weapon. Do not go back to the premises or area of 1042 East Canfield Street in Detroit. And you're absolutely to have no contact with Paris McKellar. And no contact means no contact of any kind. No contact orally, in writing, through a third person at their place of residency, employment, or through any forms of social media. No contact with Paris McKellar of any form. Is that clear?
Yes.
And thank you. Based on the allegations in the investigator's report and the nature of this charge, you're to be fit with a GPS tether prior to release. Your bond is going to be set $10,000 personal bond. You're going to be released without posting any money, a personal bond, ma'am. Listen to the court. Ms. Huffman, you have two jobs. What are the hours of those employment so I can indicate on the tether that you can go back and forth to employment?
It's different times.
Okay.
I work at one. I don't work at Walgreens anymore, but I work at a grocery store, and I don't have a set schedule yet. I just started.
Okay, so you don't know when you'll be working.
I mean, I just started. I start work tomorrow. I go back to work tomorrow at 9 o'clock until 3. But my set schedule is not going to be made until next week.
What time does the grocery store open, Ms. Huffman?
I couldn't hear.
What time was the grocery store? What time does it open?
It opens at 10, but I go tomorrow at
Okay.
What time does it close?
What time does it close, ma'am?
7 o'clock.
So is it about an hour after close where you take the clean up?
Do you stay till closing? Do you stay till closing?
Sometimes I do.
But you haven't started yet, so how do you know?
I started Monday, but I work from 9, sometimes I work till 6 o'clock. Is the latest.
Okay.
Get it like, potentially, like 8 to 9,
Will they open at 9?
The grocery store opens at 10, they have it there an hour early, and it closes at 8, but clean up.
What are you asking for, counsel?
I'm asking, we start from 8 a.m. to 9 p.m.
Ms. Huffman, the court is going to follow counsel's recommendation. You can go to work from 8 a.m. until 9 p.m. That's only if you're working those hours. If you're off early, Ms. Huffman, you have to go back home. If you get off at 3, 4, 5, 6 o'clock, you're not to be out and about until 9 o'clock just because you have the permission of the court. The permission lies when you're at work. So if you're at work, you can leave early. At 8 a.m. you're home, as counsel stated, give you time to get there plenty early before it opens. And until 9 p.m., the court wants you home at 9 p.m. As stated, if you're not working, you're to be at home. Does that all make sense?
Yes.
And is that Monday through Friday you work, or is that 7 days a week, or do you know?
I don't know yet. I won't have my set schedule until next week.
Okay, so anytime you're working, it's 8 a.m. to 9 p.m. only allowed when you're working. Make sense?
Yes.
And for those reasons, your bond is set $10,000 personal bond with a tether and the conditions of no contact with Ms. McKellar and no weapons. You're being released on a personal bond, Ms. Huffman. Absolutely no contact with Paris McKellar. And good luck with everything, including your employment. I hope it works out for you.
Thank you.
You're welcome. Officer, any males or females you're aware of at 48 hours that can't wait till tomorrow?
That's all we have, Your Honor. Thank you.
I thank you. Have a nice evening. Be safe, sir.